But also, I think what's really intriguing about the Cuccinelli suit is that it's what I'm calling a sort of aspirational view of the Constitution. Cuccinelli doesn't like much about the 14th Amendment, the 17th Amendment. There's whole chunks of the Constitution that he wants to do away with, right? He's challenging the EPA's power to regulate. He's challenging the birthright citizenship provisions of the 14th Amendment. So he has a sort of a cut and paste view of the Constitution. And I think this is not just about the Obama health care law. I think this is about a rather radical rewriting of the Constitution and a sensibility that there are enough judges out there. And Rachel, I've said this often to you in the past. President Bush appointed 1/3 of the sitting judges on the federal bench. And I think there's a real hope that those judges are going to not look at what the Commerce Clause has said, what precedent has said, what case law has said, what has happened in the court since 1942 when the judges started thinking about the Commerce Clause. I think this is a lawsuit that aspires to something different, that aspires to really fundamentally rewrite the Constitution. And I think there's a real hope that there's enough judges out there, including maybe at the Supreme Court, who agree with that project, that they think they really have a shot at this.
Conservative constitutional radicalism is, I think, becoming well known in legal circles, and the political impact of it is sort of only starting to trickle down into how we understand how our politics is working. But I think you're right that this is one of those cases in which it all becomes very, very, very clear.